Hello, you're watching Addleshaw Goddard's Employment Channel news programme. As this is the first programme of the new year, we're going to recap on where we're up to in terms of employment law developments. And so in today's programme, we're going to summarise some of the key developments over the past 12 months. And we'll also take a quick look at some of the most important changes on the horizon. So, in terms of key employment legislation, 2011 proved to be another busy year in the employment law calendar. We saw the abolition of the default retirement age, with the last retirement notice effective from the 5th of April for retirees aged 65 on or before the 31st of September, and the introduction of a long stop date for retirements to take effect from the 5th of October 2012. We also saw the introduction of additional paternity leave for fathers of babies with an expected week of childbirth on or after the 3rd of April. So fathers are now entitled to take between 2 and 26 weeks paternity leave from the 20th week following the child's birth, provided the mother has returned to work. The agency workers regulations also came into force from the 1st of October, under which agency workers are entitled to the same rights, such as pay and holidays, as permanent employees after being in the role for 12 weeks, plus a number of other rights from day one of employment. You can watch our Employment Channel programme broadcast in October for full details of the agency worker regulations by scrolling through the list of programmes to the right of the screen. And finally, we also saw the introduction of the Bribery Act on the 1st of July, which includes the adequate procedures defence if an organisation takes all reasonable steps to prevent bribery. Again, please do watch our Employment Channel programme broadcast on the 7th of April for full details of the Act. Moving on now to key case law developments in 2011. Sarah Wade, an associate in our employment team, discusses some of the key cases to be aware of.
In 2011, we saw some very interesting decisions handed down in the employment tribunals, some more helpful for employers than others. The Employment Appeal Tribunal case of Eversheds and de Bellin was no exception, and the tribunal here confirmed that special treatment should not be afforded to employees who are pregnant or on maternity leave unless it's necessary to compensate for the disadvantage of her condition. In Dunkerman Secretary of State for Children, Schools and Families, the Supreme Court ruled that the scope of UK employment law should extend to those working overseas, where there's a sufficiently strong connection with Great Britain and UK employment law. In terms of protection of confidential information, the High Court ruled in Brando Advisors and Chadwick that the transfer of confidential information to a private email address was a repudiatory breach of contract by the employee, even though there was no business competition element, so a helpful case for employers. And another reassuring case for employers was Wardle and Credit Agricole Corporate and Investment Bank, where the Court of Appeal ruled that the employment tribunals should not normally award career-long loss to employees, except in exceptional circumstances where there's no real prospect of an employee ever obtaining an equivalent job. In the Governors of School case, the Supreme Court confirmed that employees have the right to legal representation at internal disciplinary meetings, where the outcome will substantially influence the determination of separate civil proceedings, which in turn will profoundly damage the employee's career. The AutoCleanse case was another useful decision, where the Supreme Court ruled that express contract terms can be set aside where they do not reflect the true agreement of the parties, and there's no need to show an intention to mislead. And finally, we saw a number of cases in 2011 involving the misuse of social media. In Gosden and Lifeline Project, the tribunal found that it was fair to dismiss an employee who expressed sexist and racist views in a private email sent from his home computer to a colleague. In Priest and JD Weatherspoon, a pub manager was fairly dismissed as a result of comments made on Facebook which were rude and abusive about two of the employer's customers. In Whittam and Club 24, an employee's dismissal for making derogatory comments about her workplace on Facebook was unfair, as the comments were relatively minor and there was nothing to suggest that the employer's relationship with a key client had been harmed or jeopardised as a result. And finally, in Crisp and Apple, a tribunal found that an employee had been fairly dismissed for posting comments on Facebook that criticised Apple products and services. So all in all, some interesting decisions this year, but no doubt there'll be more case law developments in 2012.
Thanks, Sarah. So what can we expect in the year ahead? There's no doubt that case law developments will continue apace, but in terms of key legislative changes on the horizon, there are a number of fairly radical plans proposed following the government's consultation in early 2011 on resolving workplace disputes. These changes aim to help parties resolve disputes without recourse to a tribunal, but if matters do escalate to a tribunal, they aim to ensure that cases are dealt with more efficiently and effectively. We reported on these proposals in our news programme on the 1st of December, which you can access by scrolling through the programmes to the right of the screen. And in brief, the qualifying period for unfair dismissal is set to rise from 1 to 2 years from April 2012. And fees will become payable in employment tribunal cases in either 2013 or 2014, depending on which fee structure is adopted following current consultation on this issue. From October 2012, we will see the introduction of the pensions auto-enrolment provisions, under which employers in Great Britain will be required to automatically enrol eligible job holders into a pension scheme. The law will be implemented over a period of 4 years, starting with larger employers, and each employer will be given a staging date from which the requirement will be mandatory. For full details of the pensions auto-enrolment provisions, please refer to our programme at the end of October, with a further update on the 12th of December, which again you can access by scrolling through the list of programmes to the right. And finally, the government published its plan for a culture of flexible, family-friendly employment practices in May 2011, following its consultation on modern workplaces. And this included a number of key proposals for the year ahead in relation to annual leave, flexible working and flexible parental leave. In terms of annual leave, plans are underway to revise the way annual leave is dealt with under the working time regulations, in particular in relation to carrying over and the accrual of annual leave where an employee is absent on long-term sick leave. It will be interesting to see whether these changes incorporate recent case law developments on the issue of holidays during periods of sickness absence, as referred to in our news programme on the 25th of November. Another change is that the right to request flexible working will be extended to all employees with 26 weeks continuous employment, and this is likely to come into force in 2013. And fathers will be allowed to attend antenatal appointments, and there will be an 18-week maternity leave period followed by a new 34-week shared parental leave period. This is likely to come into force in 2015. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.